Euthanasia refers to the practice of intentionally ending a patient's life to relieve them from severe and incurable suffering. It usually involves medical intervention and is often described as physician-assisted death. The concept is closely linked to questions of dignity, compassion, and the right of patients to avoid prolonged suffering when recovery is no longer possible. Euthanasia debates often arise in cases where patients are terminally ill, permanently unconscious, or suffering from conditions that make recovery medically impossible. One such condition is a vegetative state in which a patient may appear awake but has no awareness of themselves or their surroundings. In this state, patients show no meaningful response to stimuli and cannot communicate or understand language. Doctors describe a vegetative state as a condition in which awareness of the self and the environment is completely lost, even though some basic bodily functions may continue. When this condition lasts for more than a month, it is called a persistent vegetative state. If it continues for several months or years without any possibility of recovery, it may be classified as a permanent vegetative state. In such situations, families and doctors often face difficult decisions about whether continuing life-sustaining treatment serves any meaningful purpose. This is where the debate around euthanasia becomes particularly significant. On March 11, 2026, the Supreme Court of India authorized passive euthanasia for 32-year-old Harish Rana, who had been in a persistent vegetative state for over 13 years. Rana's condition dates back to August 2013, when he was a 20-year-old B.Tech student at Punjab University. While celebrating Raksha Bandhan, he fell from the 4th floor balcony of his paying guest accommodation in Chandigarh. The fall caused severe traumatic brain injury and left him with 100% quadriplegic disability. Since then, he had remained bedridden, unresponsive, and dependent on medical support, such as a tracheostomy tube for breathing and a feeding tube for nutrition. For more than a decade, his parents cared for him while struggling to meet the cost of long-term treatment. They reportedly sold their house in Delhi and moved to a smaller flat in Ghaziabad. In July 2024, the family approached the Delhi High Court seeking permission for passive euthanasia. The court rejected the plea, stating that since Rana was not dependent on a ventilator, withdrawing treatment would not be legally possible. Later that year, the Supreme Court also upheld the High Court's position, noting that removing the feeding tube at the stage could amount to active euthanasia. However, the case continued. In January 2026, Justice J.B. Pardiwala and Justice K.V. Vishwanathan personally met Rana's parents, who said continuing treatment would only prolong his suffering without any chance of recovery. After reviewing medical reports and legal principles, the bench delivered its final judgment on March 11, 2026. The court ordered that Harish Rana be admitted to the AIIMS Palliative Care Center, where a structured and medically supervised withdrawal of treatment would take place to ensure he could pass away with dignity. The judgment also broadened the meaning of life support, stating that clinically administered nutrition and tube hydration are medical treatments that can be legally withdrawn in appropriate cases. The bench further urged the Union government to consider enacting a law on passive euthanasia so that families in similar situations do not have to face long legal battles. The Supreme Court also clarified the distinction between active and passive euthanasia. Justice J.B. Pardiwala explained that the difference lies in the source of harm that leads to death, rather than simply whether an act is done or omitted. Active euthanasia involves directly causing a patient's death through a new medical intervention, such as administering a lethal injection. In such cases, death occurs not because of the illness itself, but because of the intervention. For this reason, active euthanasia is considered a deliberate act that interrupts the natural course of life. Under Article 21 of the Constitution, which protects the right to life, such an act would require explicit legal authorization through legislation. As a result, active euthanasia remains illegal in India. Conversely, he explained that passive euthanasia should be grasped as allowing death to occur. Passive euthanasia involves withdrawing or withholding life-sustaining treatment that artificially prolongs life. In this case, doctors are not introducing a new cause of death. Instead, they allow the patient's underlying medical condition to take its natural course once medical interventions are stopped. The court emphasized that even when treatment is withdrawn, doctors must continue to uphold their duty of care and ensure that the patient's dignity and comfort are maintained. The debate around euthanasia continues to evolve globally. In June 2025, the UK House of Commons passed the Terminally Ill Adults End of Life Bill, which would allow physician-assisted dying for mentally competent adults expected to live fewer than 6 months. The proposed law requires medical certification and oversight by a national panel and is currently awaiting approval from the House of Lords. India has taken a different approach. Through a series of Supreme Court judgments, the country has recognized passive euthanasia while continuing to prohibit active euthanasia. However, despite this legal recognition, the process remains difficult in practice. The current system requires advance directives or living wills, approval from multiple medical boards, and sometimes judicial oversight. These procedural steps often lead to long delays. For families dealing with terminal illness, such delays can worsen suffering. Reports from hospitals suggest that many families are forced to make end-of-life decisions informally, leaving doctors in a legally uncertain position. Legal scholar K. Kannan argues that India does not necessarily need to adopt active euthanasia, given its social realities and healthcare constraints. Instead, the focus should be on improving the implementation of passive euthanasia. Proposals include digitally registering advance directives, empowering hospital ethics committees to review requests quickly, and strengthening oversight systems. Such reforms could help ensure that India's constitutional promise of dignity in life also extends to dignity in dying, while safeguarding vulnerable patients from misuse. Around the world, several countries have either legalized euthanasia or physician-assisted dying, while others are currently debating similar laws. One of the earliest examples is Switzerland, which allowed assisted dying as early as 1942. In the United States, physician-assisted dying is legal in several states starting from Oregon in 1997. In Europe, the Netherlands and Belgium were among the first countries to formally legalize euthanasia in 2002. Canada introduced its system of assisted dying in 2016. In Australia, voluntary assisted dying was legalized in 2019, starting with the state of Victoria. Spain approved a euthanasia law in 2021. In South America, Uruguay is the only country to decriminalize euthanasia in 2025. Together, these developments show that the global debate over euthanasia and assisted dying continues to evolve.